5 seconds to go. Start. It would result in undue hardship and inconvenience to the employees of the central government itself who are posted across the country. Shri Shyam Diwan, learned senior advocate, has taken us to the historical background of Article 226 of the Constitution of India and the development of the law on the jurisdiction of the High Courts, including the statement of objects and reasons to the Constitution, 15th Amendment Act 1963, and the remarks of the then Law Minister at the time of introducing the amendment. It is submitted that in the subsequent decision of this court in the case of Kusum Ingots and Alloys Limited versus Union of India and another 2004-6 SCC 254, which was after the introduction of Article 226(2), has observed and held that the High Court would have jurisdiction if a part of the cause of action arises in its jurisdiction, irrespective of location, residence of the authority. It is submitted that this court in the case of All Chemist Limited and another versus State Bank of Sikkim and others 2007-11 SCC 335, noting the development of law in relation to the territorial jurisdiction of the High Courts under Article 226, has held that the legislative history of the constitutional provisions therefore makes it clear that after 1963, cause of action is relevant and germane, and a writ petition can be instituted in a high court within the territorial jurisdiction of which cause of action in whole or in part arises. It is further submitted that the observations made by this court in the case of L. Chandra Kumar Supra that all decisions of tribunals would be subject to scrutiny before a division bench of the High Court within whose jurisdiction the tribunal concerned falls is not an exclusion of the jurisdiction of the other high courts which may have jurisdiction, particularly under Article 226(2) of the Constitution of India. It is submitted that, therefore, the judgment of this court in the case of Alapan Bandyopadhyay Supra may require reconsideration. In support of his above request, he has made following submissions. The judgment of this court in the case of Alapan Bandyopadhyay Supra arose out of an order passed by the chairman Central Administrative Tribunal exercising powers under Section 25 of the Administrative Tribunals Act 1985, transferring the OA filed by the respondent therein from the Calcutta bench of the Central Administrative Tribunal to the principal bench at New Delhi. The said transfer order was quashed by the Calcutta High Court by allowing the writ petition filed by the respondent therein. The order of the Calcutta High Court was challenged by the Union of India on the ground that a challenge against the order passed in the transfer application by the Central Administrative Tribunal Principal Bench at New Delhi was maintainable only before the High Court of Delhi, as the principal bench of the tribunal lies within its territorial jurisdiction. This Honorable Court, referring to paragraph 99 of the judgment in L. Chandra Kumar Supra, held that any decision of the tribunal can only be subjected to scrutiny before a division bench of a high court within whose jurisdiction the tribunal concerned falls. Consequently, it was held that the jurisdiction lies with the High Court of Delhi, since the principal bench of the Central Administrative Tribunal is located at New Delhi. It is submitted that the relevant paragraphs from the judgment of this Honorable Court in Alapan Bandyopadhyay Supra are reproduced herein below. In view of the reasoning adopted, the Constitution Bench in L. Chandra Kumar case, L. Chandra Kumar versus Union of India 1997 3 SCC 261, 1997 SCC L&S 577 held Section 28 of the Act. Stop.